Well, hello there. Employment Law Show. We are back. So good to have you here for the half hour. Feel free to just tuck in and learn lots over the next 30 minutes about your employment rights, your workplace rights. That's why we've been doing this show for so many years. John Scholes here alongside Lior Samfiru, employment lawyer from Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. You can always reach out anytime for more of a casual, lengthy phone call if that's what you wish. Lior's got a great team with him. 1-855-821-5900. Help at employmentlawyer.ca. And there's a great website called pocketemploymentlawyer.ca. We will refer to that website several times during the show. I can guarantee it because what's involved with that is a learning opportunity. Most of the things we talk about on this show are rolled into that website, and also the severance calculator, severance pay calculator. You can use that anytime. Millions of Canadians have used that, had their eyes opened up as to what severance really should be, not the number you've been offered on that little piece of paper when you were let go. So don't sign anything and stay tuned for lots more. The main topic a little later on will be rights for older employees. It's going to be a true or false. We love those. So we'll get to that here in just a bit. But, Lior, we always start off with the case of the day or a week that was, pal. What do you got going on?
Hey, John, great to be here. Of course, great to talk about employment law. And over the past week, I've spoken with a lot of individuals that have seen our show that didn't even realize that they had certain rights until they watched us here and they realized, wait a second, what my employer is doing is not right. I have rights. I have options. There's things that I can do and there's places I could go to for help. So that's exactly why we do this show every single week, because we want to arm you with that knowledge. We want to talk about things that you may come across. You know, hopefully things are good right now, but at some point, something may happen that makes you unhappy, that puts your job in jeopardy, that creates changes to your terms of employment. And what do you do in that if that happens? How do you get answers? How do you get help? Well, on the show, we addressed all those things. It's very important that we all have knowledge about employment law. We have jobs, we work, we spend a lot of time, more time working than we do anything else. Well, knowing the laws that impact that aspect of our lives is so important. A lot of misconceptions out there when it comes to employment law. A lot of false information or half information online and elsewhere, but not on this show. On this show, we tell you what you need to know, the full story, the real facts, and all the options that you have. So those are the rights you may not have even realized that you had. And of course, if you want to reach out to me to connect at the office so I can roll up my sleeves and get to work for you, we'll give you that contact information throughout the show. And John, let me talk about a situation that came across my desk. I often have calls from people that have dealt with a workplace harassment issue. Well, this is one of them. This particular lady that I spoke with was being mistreated by her supervisor, her direct supervisor. He was putting her down. He was rude and obscene even. And she did exactly what she should have done in response. She went to HR and she told HR what's happening, and she asked HR to help her. Well, HR then, as far as she knows, went to speak with the supervisor, and they told him, no, you can't do that. You need to treat her better. And for a while, things were fine. For a couple of months after that, there was no issues. Things were much better. She was very happy. Well, after a couple of months, slowly but surely, things went back to the way they were, where he was being mean, he was being disrespectful, obscene, vulgar, completely inappropriate in the workplace. Well, she went back to HR, and she said, this is happening again. Well, HR at that point kind of threw their hands up and said, well, we've already spoken with him. I don't know that there's much more that we can do. You and him are just going to have to figure out a way to make this work. We've done what we can. Well, of course, frustrated and frankly on the verge of a bit of a breakdown, she called me and she wanted to know what her rights were. Well, John, her employer did not have the ability, HR, to say, one time we've tried, therefore we're good, we don't do this again. No, it's the employer's obligation to solve workplace harassment, to deal with it, to take it seriously. They don't get to say, well, we've tried one time, now we're out of options. Whether that means they have to discipline this person, give them training, maybe letting them go or transferring him somewhere else, they have to deal with this. And in this situation, their refusal to do that, number one, that could be a constructive dismissal. She can treat that potentially as a termination because why? Her employer is not allowing her to continue working in a healthy work environment. And of course, that could also be a violation of several other statutes. It's illegal. So if you are being mistreated, harassed, bullied in the workplace, your employer has to take it seriously, to investigate and do what it can to rectify the problem. There is no point where they get to give up on that. It doesn't work that way. And if you're tried that and you haven't been successful, your employer is not doing what it's supposed to, let me have a crack at them. Oftentimes when they hear from me, things happen and things move along very quickly. So don't ever accept no from your employer when it comes to dealing with workplace harassment.
What always comes up, and we always continue the conversation with this topic, Lior, when it comes to harassment is, if you've got a very large company with a seasoned, robust HR section, department, they should be able to handle this, and it should be not routine, but they should be able to do a good job. But if it's like a little mom and pop shop, right, maybe 3 employees, or maybe if it's the boss himself who's doing the harassing, you're going to feel kind of stuck.
And you're right. If it's the owner and your little small company that's harassing you, who are you going to talk to? And at that point, there's really no one to talk to internally. That's why we go externally. You call me right away and you let me deal with it. We can get you out of that workplace, get you compensation so you don't have to continue suffering. Too many times, John, I've seen employees that because they've been bullied and harassed and they didn't really deal with it, or their employer didn't deal with it, they end up going on a disability leave, stress leave, anxiety, depression, insomnia. Don't let that happen to you. Your employer has to obliterate this problem to resolve it. And if they won't, or you don't know how to approach them, let me do it.
And how you do that, by the way, 1-855-821-5900, anytime to call Lior. If you want to send an email, that's an option, help@employmentlawyer.ca. Just the website, though, employmentlawyer.ca. Among things you could do on that website is find links to our long-running radio shows. For about 10 years, we've been doing those across the country. We give all kinds of information out 7 days a week on those radio shows. You can tune into a station near you. You have an opportunity most of the time as well to give us a call on air and ask your questions. We want to get to our first phone call from the radio show today, right here and right now. Let's have a listen.
My brother was with a company for about 15 years. He was a manager. He got lured away by another company, and he got let go within a year. And just wondering if he's got any recourse with that company. No severance. I think he got like a month pay. So he's stuck now with nothing and lost career that he had, good, stable job.
The old inducement.
That's right. And this is something that happens fairly often, especially these days when employees are recruited from one job to go to another job. And the reason we need to talk about this is very important here is the fact that if you've been recruited from another job, you weren't out there shopping your resume, you weren't looking to leave, another company came to you, they knocked on your door and they convinced you to leave. You leave, and eventually they let you go. It doesn't work out. They let you go in the first couple of years or so. Well, wait a second. Now they have to pay you enhanced severance. Severance that recognizes your time with the previous company. So in this situation, this guy worked for 15 years with one company. He was recruited away. He wasn't looking to leave. He only worked for 1 year with the new company. Then they let him go. Well, now they should pay him severance like a 16-year employee, even though he only worked there for 1, because they have to account for the time that he had with the previous company, the one they recruited him away from. So, of course, the question now that we know that he should be getting severance for 16 years of service, how much severance? How much does he actually get in this situation? Well, we're going to go, of course, to pocketemploymentlawyer.ca. And we're going to use our severance calculator tool. And let's see how much severance he's owed after those 16 years that he gets credit for. So, length of employment, it says 15, but it's actually 16 years, 15 plus 1. He's not offered much severance. Well, you see on the screen right now that he could be owed as much as 18 months severance. 18 months. Now, John, he only worked for the company for 1 year. 1 year, 12 months. And he could be owed easily 18 months of severance. So 6 months more severance than the length of his employment. And it's because he was recruited from another company. So for all our viewers, if you are recruited from another company, things don't work out, you're let go, you're owed enhanced severance.
This recruitment topic is worth drilling down a little further on, Lior. Now, as far as when that happens, when you are pulled from your current job, a job you're happy at, you didn't intend to leave, and another company wants to bring you on, there's an amount of risk on both sides, right? The employee coming and the employer who's bringing in this person. How do you mitigate that risk for both sides, for the employer and the employee?
Well, I think that the key here is that if the employer is the one knocking on their door, if they've decided you're the right person, we want you, well, I think that an employer should bear more of the risk because that employee is leaving a secure job that they weren't looking to leave. So I think it's only fair that the employer bear that risk. Now, one of the ways what the employee doesn't want to bear the risk is don't agree to a probationary period. Don't agree to be on probation once you're leaving a secure job that you weren't even planning on leaving. It makes no sense. Don't agree to terms that limit your future severance. That could cost you a lot of money. Be very careful with that agreement. Now, if you were talking from the perspective of the employer, well, the opposite is true. If you are an employer, you'd like your employee to have a probationary period. You'd like to limit their future severance. So depending on which perspective you're looking at, employee or employer, that employment agreement becomes an extremely important document.
And that's where the negotiation comes back and forth, a little bit of a tennis match till you decide on something, right? Because they both have something to lose.
Absolutely. And frankly, if you've been recruited from another job, you probably have a lot of negotiating power. You have some leverage because the company really wants you. So you can afford to negotiate terms that are favorable to you.
Terminationquestions.com, and a website you can use anytime. You can just get on your tablet or your cell phone. You can type in questions to Lior. His team will answer them quickly and succinctly. Here's the first one from terminationquestions.com. Check it out. It says, after returning from maternity leave, my employer has requested I sign a new employment contract. I'm not sure why this is necessary. Am I obligated to sign this?
Well, no, it's not necessary. It's not required, and in fact, it's a terrible idea to sign this. Whether you're coming back from maternity leave or for any reason, you're working, the company all of a sudden says to you, we want you to sign a new employment agreement. No, it's always bad news. The only reason, and I mean the only reason, a company is going to want you all of a sudden to sign a new employment agreement is because that agreement provides for better terms for the employer. They're not going to give you and insist you sign an agreement that provides you with better terms. No, why would they do that? It provides for better terms. It gives them the ability to let you go with minimal severance. It may give them the ability to put you on a temporary layoff. It may give them the ability to change your job, your compensation. It may try to sneak in a non-competition obligation. You name it, it's not a good idea. So in this situation, I would tell her, simply say no. Absolutely not. I'm coming back to work from my maternity leave, not signing any employment agreement. I'll see you Tuesday when I'm back. They can't do anything to her. They can't fire her because of that. They can't discipline her because of that. And same applies to you in any situation. If your employer wants you to sign that new employment agreement, before you put your name on that line, call me. Let me see that agreement, send it over. Let me tell you what it does. Chances are it's a document you don't want to sign.
Let's get into a short break. On the other side, rights for employees, older employees, true or false? That's how we're going to handle that one. In the meantime, here's that number again, 1-855-821-5900. help@employmentlawyer.ca through email as well. More Employment Law shows coming right up. Stand by. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back, Employment Law Show. So good to have you along for the half hour. You want to reach out afterwards and like, oh, I have a phone call with Lior or one of his team. You can do it. Always available, 1-855-821-5900. Email is help@employmentlawyer.ca. And that website, again, you can go there anytime, pocketemploymentlawyer.ca. Okay, rights for older employees, true or false? I'm asking the questions. Otherwise, there'd be trouble. First one, employers do not have the right to terminate employees due to their age.
That is true. And not only is it true, it's very important to remember that as well. Your age should not ever form any part of a decision to either fire you or even to hire you. So you cannot be let go because of your age. We got rid of mandatory retirement in this country many years ago, okay? 15 or 20 years ago now. And because of that, your age is a non-factor. Human rights laws protect you from having your age being even a consideration. We have an aging workforce throughout the country, but that doesn't matter. You can work till 65, 85, whatever it is that you decide on your own. And if your employer considers that age, even if it's not the only reason. So they may have 3 reasons they let you go. Some of it that the business is slow, some of it that they're restructuring, but your age is one factor. That is illegal as well. Age should not be a factor. So if you're ever in a situation where you're let go, you're the only one, you've been there the longest, but everyone else is younger than you, they haven't been let go, guess what? It's going to be hard for the employer to say that age was not even a factor. That's illegal. It's a human rights violation. That the law is going to come down very hard on any employer that does that. If that's your situation, we really do need to talk.
Okay, true or false? Number 2 goes like this. Employers have no legal obligation to make changes to someone's job if their age is impacting their productivity.
So that is false. And the reason it's false, of course, is, an employer does have to accommodate, does have to make changes to your job if your age, if your health are impacting your job. Now, it's very important then to be honest with your employer and tell them about that. Because if they're not aware, if they just think you're not doing a good job, but they don't realize that maybe your age is a bit in the way or your health is in the way, they may just think you're not doing a good job, so let's get rid of you. But if you've told them, you're actually protecting your job. They may want a doctor's note if there's a health issue, and that's fine to provide that doctor's note because that triggers their duty to accommodate. But if your age is impacting you, it doesn't mean, number one, that you can be let go. It doesn't mean you have to retire or resign, not at all. Your employer can still meet that obligation to accommodate by making changes to your job. Maybe it's modified duties or light duties. Maybe it's the ability to work from home sometimes. And oftentimes, the starting point can be talking to your doctor and telling your doctor what you need. And if your doctor agrees, they provide you that note. That makes it happen.
This week on the show, of course, right now we're doing the rights for older employees. True or false? Number 3 is this, Lior. Employers cannot pressure an employee to resign or retire because of their age, golf pamphlets, stuff like that.
John mentions golf pamphlets because it's a true story. I had a client some years ago where the company really wanted him to retire, and they kept leaving pamphlets for retirement residences and golf resorts. Well, wouldn't you really want to be here instead of working employee?
Brutal.
Hint, hint. Yeah, it's brutal, but it's also illegal. Yep. Your employer can't make you resign. First of all, the only one that can decide if you resign or retire is you. Okay, you should never retire or resign because you're put under pressure. That makes it an illegal resignation. That makes it an illegal pressure. That could be considered a termination, even though you're the one that has uttered the words, "I'm retiring, I'm resigning." You did it because of the pressure. But even suggesting that you should, even telling you, hey, you really should consider retiring or resigning, that in itself can be a human rights violation. So employers should not do that. It's okay to ask an employee, hey, employee, do you have any plans to retire or to resign? Because we want to know to plan if you decide to. And that's a legitimate question as long as they don't ask you that every other month. But beyond that, to tell you, well, you really should, you're the old guy here, come on, don't you really want us to move on, or you're probably not getting along with all these young people, that crosses a line into a human rights violation, inappropriate completely. And if your employer does that, I want you to document that. I want you to create a written record, write it down somewhere, send someone an email confirming that that's what's happening, because if you can show that that's what your employer is doing, the law can come down very hard on that employer.
The rights of older employees, true or false? We get to one more of these. This one's a good tip of the hat to the old severance calculator, and that is older employees are typically owed more severance due to the difficulty of finding new employment.
So we're talking about the rights of older employees. One of those rights is the right to get more severance than a younger employee. It's assumed, right or wrong, that an older employee may take longer to find another job than someone that's younger. And because of that, they get more severance. They get more of that protection to allow them to have the time to find another job. So if you're 65, you're going to get more severance than if you're 45. And if you're 75, you're going to get more than if you're 65. So age is a huge factor, a very important factor. And the older you are, the more severance you get. By the way, we have our pocketemploymentlawyer.ca tool, our severance calculator tool you can find there, that calculates your severance based on several factors, including your age. So remember, you can't compare your severance to someone that's younger or older for that matter. Age can drive that severance significantly higher.
It makes sense. So if you think about it, this whole topic, we're talking about the true and false, is employers trying to get rid of older employees. What are the chances they're going to bring a fresh one in of that age when they're trying to get rid of them? It's going to be difficult to find a new gig.
It is. And oftentimes an employer may want someone that's going to be with them for many years, and they may think, maybe incorrectly, that if I hire someone that's in his 60s, he's not going to be with us for a long time, so do I want to invest in that? That, by the way, that's an illegal consideration. But the reality is that you may face that. You may not know that that's why you're not being hired. But the law recognizes that. And the way that it compensates for that is by saying, well, you're going to get more severance to give you more time to find a job, more time than you would have had if you were younger.
Again, employmentlawyer.ca, the website you go to find a website, or at least a radio station rather, across the country that takes our live radio shows. We'll get to our second phone call from one of those shows right now.
What constitutes cause? I've been at this job for about 8 months now, and I haven't really received the proper training for the job. And my boss keeps writing me up, saying that you're not doing this, you're not doing this good enough. And I keep asking him for training, and he doesn't provide the training. But I just want to know, can I be let go for cause in those situations?
And I think that's a real concern that he's having, because I think that's what the company's doing. They're trying to build up a case to potentially let him go for cause by writing him up and eventually saying, we've given you all these chances, you're not doing a good job, you clearly can't do the job, what more can we do? We're going to let you go for cause. And that happens often, but there is something that you can do about it. So he's already said that he's talked to them about training and that he hasn't been provided training. Make sure you put that in writing. So if you're written up, if the company complains you're not doing a good job, well, tell them why that is. Employer, I've asked several times to provide me training on this aspect of my job. You haven't provided it to me, so I'm still trying to figure out how to do it. So I don't think it's fair that I get written up. If you do that, if you tell them about the lack of training, the lack of support, the lack of help, and that you are asking for them to provide you with that help, that's going to make it impossible for the company to let you go for cause. They'll still be able to let you go, of course, because a company can let an employee go, but that would be a without cause termination, meaning you get severance. Now, this person, after only 8 months of employment, he still could be looking at as much as 6 months worth of severance, even after only 8 months of employment. So it's very important to preserve that right to severance, so to eliminate the possibility of a termination for cause. And you do that by telling the company why your performance may not be up to speed, what they have done not to help you, and what they can do to help you moving forward.
Quick break, and on the other side, are severance calculations different for federally regulated employees? We'll find out. Hang on for that. In the meantime, that number, 1-855-821-5900. You want to reach out through email, that's an option. help@employmentlawyer.ca. Lots more of the Employment Law Show's coming right up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, thanks for hanging in. A few minutes to go here on the Employment Law Show. To reach out to Lior on the other side, anytime, 1-855-821-5900. help@employmentlawyer.ca, and just employmentlawyer.ca, the website, the media page, to find a radio station across this wonderful country that carries our radio show weekly. So tune into that, call in, talk to us, ask your questions. You may appear on this show, and we'll discuss it even further, which we're going to do right now. Phone call number 3 from the radio show is coming up. Hang on.
So I'm a middle manager for a logistics company. We're federally regulated. I've been there for just over 20 years. I'm 42. I have about 10 or 11 people that work under me. We lost our major contract, so we're basically being told that our contract's being closed, and we're expected to get packages probably this week. And I'm just wondering what I should expect.
Remember that phone call.
So federally regulated employers or federally regulated employees. So maybe you work in railway or air transportation, telecommunications, banking, certain trucking companies. All those industries are federally regulated. And if you lose your job, the question often becomes, well, how much severance do I get? And do I get the same severance as someone that's provincially regulated? Well, it's actually quite simple. Yes, you get the same amount of severance calculated the same way. It's your age, your position, and the length of your employment that are the main factors that go into assessing how much you're owed. And you can get as much as 24 months severance. Now, your minimum entitlements may be different whether you're a federally regulated employee or a provincially regulated employee, but it doesn't matter. What matters is your full entitlements, your common law entitlements, and those are the same. Again, trucking, telecommunication, banking, etc. So now that we know that, well, let's actually put that information to use, and let's see how much severance this person gets after working and being let go, or about to be let go from his federally regulated employer. We're going to go to our severance calculator. Of course, you can find that at pocketemploymentlawyer.ca, and let's see how much severance he's owed. So he's a middle manager. He said he had people reporting to him. He's 20 years of age, 20 years of employment, 42 years of age. Company has not yet offered severance. They're still trying to figure out. Well, he knows what that amount should be, 18 to 24 months severance. You see that on the screen, 18 to 24 months. And that's a good example because the same may apply to you, federally or provincially regulated, just the same. And of course, you can go to pocketemploymentlawyer.ca to figure out how much the real amount is for you.
That could be zero up to nearly $140,000. That's a huge amount of money.
That is a massive amount of money. And oftentimes I do see federally regulated employers, especially in the trucking industry, because they may not actually have the knowledge or the resources to understand what they owe. When someone is let go, they work in trucking, whether they're a driver or a dispatcher or a manager, and the company offers them pennies, tiny little amount of pennies on the dollar. No, can't do that. That's why we have our pocketemploymentlawyer.ca tool.
You want to tune into one of the live stream chats that Lior does on YouTube and Facebook and LinkedIn as well, at ST Lawyers, at ST Lawyers. To do so, let's get to a question you had recently from that. Lior says, I was recently on short-term disability leave for a few months due to an ongoing health issue. Upon my return, I was told I was not entitled to the annual bonus as I was away. Is that legal?
Well, the answer here, unfortunately, is it depends.
Right.
So what I mean by that is, what is the bonus based on? Is it based on your performance and you achieving certain targets? If that's what it's based on, well, if you didn't achieve those targets, not your fault, of course, but if those targets weren't achieved because you weren't physically there, then the company is not going to pay the bonus. On the other hand, if the bonus is strictly based on company performance, then yes, the company still has to pay that if they otherwise met the threshold. So you can be punished for being sick, but the company also is not going to pay a bonus that's based on you doing certain things if you weren't there to do it. So it does depend. But a company that simply says, as a general rule, we're not going to pay bonuses to employees that are not there if they're sick or if you're on a parental leave. That could be illegal. That could be a human rights violation, could even be a constructive dismissal. So it is worth making the call and understanding in your specific situation, do you get the bonus or do you not?
Get to a quick email question here before we wrap for the show. Lior says, I've been employed by the same family-owned company for 12 years. The business just sold to a big corporate company and will be relocating. This new location adds a great deal of time to my commute. Do I have any options here?
Very common situation, especially when a sale of a business happens where you may continue working, that they're offering you a job with the buyer, but it's at a different location. So the question becomes, how far is it? Right. Not in terms of kilometers. We don't care so much about that. It's how much more time is it going to take you to get to work? What's your commute going to be like in comparison to what it was before? So the rule I kind of use is an hour. Is it going to be more than an hour extra to get to work or to get home from work? If the answer is yes, then you don't have to accept it. That becomes a constructive dismissal. You're going to be owed severance. So that's the threshold that I use, 1 hour. Anything less than that, probably not something that you can do anything about. Anything that's an hour or more, and I've recently spoken with someone who was going to be 90 minutes. Don't have to accept it. If you lose your job, you are owed severance. You haven't resigned. So keep in mind that 1 hour relocation.
Do you have an opportunity to maybe try it out? Maybe the new place there's a great pizza joint across the street. Maybe I might not mind working there, but can you take it out for a spin possibly and reject it if it doesn't fit into your lifestyle?
Well, if it's a pizza joint, that's
a
game changer right there. No, but yes, absolutely, because you may not know how it impacts you. I think it's bad, but it may not be so bad. So you tell your employer, hey, employer, I have real concerns about being able to make this extra drive to the new location, but I'm willing to try it. So just so you know, I'm going to try it for a few weeks, and I'm going to let you know how it goes. So you can do that for 2, 3, even 4 weeks. And after that period of time, if it's not working well, you can still say constructive dismissal, but make sure in writing you tell your employer that's what you're doing.
And that is it. The punch card is full for another week. Thank you so much for your contributions to the show and tuning in. You can always reach out now that we're done. Phone call 1-855-821-5900. That email address is help@employmentlawyer.ca. And finally, that website, pocketemploymentlawyer.ca as well. We'll see you next time in the Employment Law Show.